Or
Awesome. Hello, everyone, and a very good afternoon or good evening to whatever part of the world you're in. Hello to all of those who are watching this in future as well. My name is Aashna, and today we, on the behalf of Beveron Technologies, bring you another live event on space of data privacy in the UAE, which is much, talked about issue, but yet a lot of questions are unanswered. And again, much gratitude to Brijesh sir, whose idea has elevated the legal tech space in the UAE, where his mission is to inform and educate as many law students or potential lawyers who wish to build their career in the UAE by bringing in these series of live events every now and then. Just a little background about Brijesh sir for those of you who don't know. He is a legal tech entrepreneur based in the Dubai. He has 25 plus years of expertise in emerging technologies. He is an authority in legal tech consultancy with great knowledge of technology trends and their effective application in the legal domain. He has practical experience for delivering corporate-wide legal tech solutions across Middle East, Africa, and Indian subcontinent region as well. Also, Brijesh sir has written a book on legal tech and authors several articles. Thank you so much, Brijesh sir. Let's have few words from you before we begin the session.
Thank you, Aashna. Thank you for the introduction. Okay. So about this group, we have an active group of smart lawyers in UAE. We have a great mix of lawyers in house legal department, legal counsels, legal students, and technology aspirant, legal tech professionals. In the group. Okay. We used to conduct this kind of sessions in every week. Okay. So we conducted the similar sessions earlier as well. Okay. So I hope this will be much beneficial for all this the community that we are that are here in the group. Okay. I understand that most of the people who are attending this session are members of the group, and also we posted in LinkedIn, and many people responded. I understand that more than 30 people have responded to the event. But since it is Saturday afternoons, many people are work at their office, and for other people it's a relaxing time as well. So I think hopefully more people will be joining after some time, and it's good that you are doing the recording, so all people can watch it later. And today's session, is a very interesting topic, the data protection or data privacy. So everybody is very keen to know about data privacy or data protection. Everyone knows about the GDPR, and what is the version of GDPR in UAE? What is the law says about data privacy, data protection? We are very keen to know that one, and we are very excited to get the speaker in today's session. Souryan Bhattacharya. He's the security consultant in First Gulf Bank. So it will be much beneficial, much insightful, I hope, for all the attendees here. And thank you for Souryan, for coming forward to present your topic in this today's session. And I hope everyone it will be much beneficial for all the team members. Thank you.
Well, thank you so much, Brijesh sir. And indeed, Souryan, it's a pleasure to have you here on board. Honestly, I understand it's afternoon, not many people would show up. However, we're going to record this live session and share it with all of you who will be watching this in future. We will be taking the small snippets from today's webinar or live session and posting it on our social medias so that more and more people can be benefited, because data privacy is something which a lot of people misunderstand. They misunderstand it for data security, or they feel that this is a career field which only tech professionals can choose. So there are a lot of taboos as well around this particular profession, which Souryan, I would be interested for you to break those. And little bit about Souryan, of course, sir has given a great, understanding about what exactly Souryan does. But apart from that, indeed, he's working as a consultant in the data privacy office in First Abu Dhabi Bank, But apart from that, he is a CISA and CIPPE qualified, which is one of the most prestigious qualifications when it comes to privacy. Apart from that, he's also the founder for the Center for Specialization in Cyber Laws Studies at Symbiosis Law School, Hyderabad, situated in India. He also assists his organizations with data privacy compliance on a group level as well. Well, thank you so much for joining in, Souryan, and over to you now.
All right. Thank you for having me, Aashna and Brijesh. Thank you for this opportunity. The main focus of today's session will be a little bit on the federal law that we have here in the UAE, and I'll give you some practical tips on how we can achieve compliance. So I'll share my screen. Just let me know once you can see it. Is my screen visible?
Yes.
Yes.
All right. Okay. So I'll start off now. As I said, the topic of discussion today will be the federal law and tips to achieve compliance with these laws and few questions and answers. Just to give you a brief context on the history and of this data privacy laws in the UAE. Data privacy emanates from our UAE constitution under Article 31, which provides for telecommunication privacy. We also have a law in the Emirate of Dubai, which regulates the dissemination and exchange of information. But that is only for entity level and corporate government level data. And now in 2021, we have our own federal law throughout the UAE, which regulates the protection of data. Similarly, we also have industry-specific regulations like the Central Bank's Consumer Protection Regulation and Standards. And we have zonal regulations, which are for the free zones like ADGM and DIFC. They have their own data protection regulations, which is more or less a copy-paste of the GDPR. Moving on, just as an introduction to the federal law. This law came in the year 2021, and the objective of the law was very simple. It was to ensure confidentiality, protection of its privacy, and governance for data management. Now, when we ask which entities does it apply to, there are two concepts that we have to take care of. The first is a controller. A controller is an entity. Let's say if you decide what to do with the data and you're deciding if you're the entity who is collecting it, then you will be considered as a controller. And if you're an entity who receives instruction from another entity on what to do with the data, then you will be considered as a processor. So this law applies in three scenarios to you. Scenario number one, if you're a controller or a processor and you're processing personal data of somebody, for an individual who's based within the UAE, then this law is applicable to you. If the second scenario is if you're a controller or a processor and you're processing personal data of somebody who is not within the UAE, then still the law applies to you. The third scenario is that if you are a controller or a processor, but you're not based within the UAE, but you're still processing personal data of someone who is within the UAE, then this law will be applicable to you. Now, as we have seen in similar data privacy laws, the law does not regulate the data that is governed by the government. If you're a government authority who processes personal data, maybe for like here in the UAE, we have seen that the government takes care of the RT-PCR and the COVID-19 cases and scenarios, then this law will not be applicable to you. Same goes for the judiciary and the enforcement agencies which process personal data. Again, if you're an individual who is processing personal for a personal purpose, maybe like a personal communication, then this law will not be applicable to you. Similarly, for hospitals and for banks, if you are processing health-related data or banking and credit-related data, which is already regulated by a certain law, then this law is not applicable to you. Lastly, if you're based in one of the free zones like ADGM and DIFC is, then this law is not applicable to you, which is already covered under their own specific data privacy laws. Moving on, there are certain data subjects which are covered under this law. So the law says that any national person who can be directly or indirectly identified will be under the scope of this law. This can be interpreted in several ways. One of them can be a corporate connected individual personal data. So let's say if you have a director in a company and their name or their email ID, that will be considered as corporate connected individual personal data. Or let's say, as usual, like we've seen for general applications and general companies, that if you're an individual or a prospective consumer of an entity, then this law might be applicable to those data subjects. Similarly, this goes for the employees and for vendor or third-party connected individual data. So let's say if you have a vendor and their consultants who are working under the vendor, you need their personal data for your various purposes or contract management purposes, then this law will be covering them. Next up is how should you process that data subject's personal data. So you have two ways how which you can process the personal data. The first is that with consent. Whenever you process an individual's personal data under consent, then you have to take care of a few things. The first thing is that you have to establish that you've received their consent or the approval. Secondly, you have to ensure that the consent that you've received is given to them in a clear, simple, and unambiguous manner, which means that you cannot bundle them up in your terms and conditions. You cannot hide the terms and the requirements of the consent under the privacy policy or the stuff. Thirdly, you have to give them the option to withdraw their consent. If you are giving them the consent, then you should give them the option to withdraw them, and you should tell them that what are the requirements or what will happen to the legality of the processing once that individual or the data subject withdraws them. If you are not processing with the consent of the data subject, then you have a few legal bases under which you can do so. The first is that if the personal data is made public by the data subject, this could be data that they've uploaded onto LinkedIn or any of the social media sites which is made public. Secondly, if you process any personal data which is of public interest, this is generally will not be applicable to corporations, particularly because none of the activities that they do is generally for public interest. Thirdly, if the data is necessary for medical purposes, this could be if your employer wants to collect your COVID-19 vaccination reports for their own report sharing with the government entities, this can fall under that. Fourth, if you are processing personal data for your scientific purposes or historical purposes, this is generally for archival companies or few companies who work in the biotechnology sector. Next is that if you are processing personal data for the employment or social security purposes, so let's say if you're trying to hire somebody and you need their name, email ID, and other details, then you can, instead of processing it under consent, you can process them under this situation. Next is the performance of contract. If you're processing personal data which you require, if you're giving them a service which falls under a particular contract and you need the name or the email ID or the address to process it for that, then this will fall under that category. Lastly is for litigations and mediations and other legal proceedings. So you might need the address to give them certain legal notices. So instead of doing this in the consent, you can claim it under this current section. Moving on, if you're a controller, there are certain obligations that you have to take care of. The first obligation that you have is that you have to put proper technical and regulatory measures. This can include technology restrictions like encryption or regulatory measures which are already given by the law. The second obligation that you have is that you need to have technical measures which ensure that the data that you're collecting or processing is limited to what you want. So this can be data minimization techniques that you apply at your organization or at the application so that it collects the data that you need and not anything more than that. The third obligation that you have is that whenever you appoint a vendor or a processor, you have to ensure that they sufficiently guarantee the protection and the security of the personal data, which essentially means that whatever obligation is on you, the similar kind of obligation should be on them for the privacy and data protection part of it. Obligation number 4 that we have is that whenever an authority, and in this case, we here mean the UAE Data Office, if they are carrying out an investigation or any sort of other information that is requested by them, you have to make that available to them. And the last obligation that we have is to maintain a register of personal data. In other countries, this is very similar to what we call a ROPA, or record of processing activities. And in the in that ROPA, you need to detail a few things. The first thing is the category of personal data. So this can include, let's say, your sales team needs to collect a person's name, their email ID, their mobile number. Those categories needs to be covered. And secondly is the access rights. So generally, we'll come to this later, there may be some scenarios where you will give them certain access rights. So whenever they exercise their access rights, they have to be provided with certain information. So you have to mention whether these kind of information will be shared back with the data subject. Third thing is the restrictions and scope of processing. So there are certain, you can detail out what restrictions you want to put on a certain data. Are you encrypting it? Are you masking it? Or are you not collecting that at all? Those are the things that you have to detail in such a in that ROPA or the register that we have. The fourth thing is the cross-border transfer of data. So you have to detail whether you're sharing this data with your other subsidiaries which are not located within the UAE. And the last thing is the technical and regulatory measures for the security of data. So what technical measures you've taken on that? Are there security controls in place? Are there certain policies and procedures in place which ensure the protection and privacy of the personal data? Are those some things that you have to cover? Secondly, if you are a processor, there are again obligations that the law has provided on you. The first obligation that you have is that you have to perform the processing according to the instructions of the controller. So if the controller asks you to do X, you have to ensure that you only do X. Obligation number 2 is that you have to process the personal data according to the purpose. So let's say if they outsource a certain task for you, you cannot send that personal data to a third party or to another marketing team so that you can market certain information or certain services to the controller or to the controller's clients. The third obligation is that you have to apply as a processor. You also have to apply certain regulatory and technical measures so that you protect the personal data that you're receiving from them. Obligation number 4 is very important. That is the non-disclosure of personal data except when provided by law. So if you're receiving personal data from a controller, it is an obligation that you do not share it or do an onward transfer of that personal data to another entity until unless that is given by the law or it is allowed under the contract. Obligation number 5 is that you have to ensure that you protect the media and equipment that you use for your processing and backup. So this could include your cloud services, your IT systems, your core systems that you use for processing or any other tools which are in scope of this. And obligation number 6 is that you have to delete it after the completion of purpose. This can be under the instructions of the controller, or you might have your own obligations that you have to keep it for a certain time because of audit or for some other regulatory obligations. Moving on, the law also provides for certain security measures that are required. So if you're a controller or a processor, you have to deploy certain technical and regulatory measures. These include encryption, pseudonymization, anonymization. This can also include measures that ensure confidentiality, integrity, and availability of data. Confidentiality means that you have to keep the data safe. Integrity means that you have to keep the data as is or how it has been given by the data subject. And availability of personal data is that in cases of any malfunctions or if natural disasters, you have to ensure that the services are uninterrupted. The third measures that you can do is a continuation of the availability. In cases of let's say if there's a server failure, you have to ensure that you have backup servers in place so that you have timely recovery of such personal data or such a service. And fourth is the testing, assessment, and evaluation of the measures. So this is kind of a second line function where whatever measures that you've taken, you have to ensure that you're testing it, that it's still in compliance with the law. You have to assess whether it's meeting the obligations of the law, and you have to evaluate whether it actually complies or is there anything else that you need to do. Similar to GDPR, this law gives us a little bit of leeway. That means that it tells you that the level of security that you need to put for a certain process or a function, that has to be equivalent to the risk that is posed by the processing. So let's say if you are processing somebody's card number for a certain product or a service, then we know that that is a high risk kind of a processing. So that the security measure that you take has to be equivalent so that it covers that risk or mitigates that risk in a manner of speaking. Okay. Next is the assessment of the impact of protection on personal data. So whenever there's a certain project or a processing which might create a high risk to the privacy and confidentiality, then you have to carry out an assessment. Under certain laws, this is considered as a DPIA. But yes, and this has to be carried out specifically for a high risk kind of a situation. The law has given us certain situations what is considered to be an high risk. This can include two things. So if you're doing an automated processing or a profiling, which basically means that if you're deploying a certain algorithm, which makes a decision on the personal, the core word here being the personal aspect of a data subject. So let's say if you go to a bank to apply for a loan, and there's an algorithm which takes into account all the transactions you've been doing and tells you whether you are eligible for a loan or not. And if this process is completely automated from end to end, this will fall under that category. In those cases, you have to carry out such an assessment. Or the second situation is that if you are processing somebody's personal data, which has a large amount of biometric data, health data, racial profiling, or ethnicity assessment, those kind of processing will be considered as a high risk. And that is when you should do an assessment of the impact of protection. The next question is, how do you carry out such an assessment? That the law has provided certain steps on what you need to do. The first step that you need to do is that you need to collect all the information regarding that certain project or processing. So you have to collect, what is this project? Why are we doing this? What data is being collected for it? From where are we collecting this data? Which teams will have access to that data? And is there any cloud processing here? Are we using any vendor for this project? These are the first step that you need to collect. Once you have that sort of information, then you need to assess why we need that certain data and how this will help the project. So you have to assess the necessity of the project. Once you've assessed the necessity, the next step is that you have to assess the risk of that certain data that you're collecting or processing. So let's say we are processing card data for this certain project. So we know that the card data is a high risk, will pose a high risk to the privacy of an individual. So we can term it as a high risk situation. So once you relay that back to your project sponsor or project manager, then you need to decide what proposed measures you can take to mitigate certain risks. So you can either encrypt that certain card number, or you can mask it, or you can not use it at all if it's not required. So these are the certain measures that you can take. On continuation with that, the DPO under the law has to be involved in such an assessment. And in certain areas, they might have to even carry out such an assessment for this. The next thing that we move to are when we transfer data outside the border of the UAE. So cross-border transfer of data can happen under two circumstances. The first circumstance is when we have an adequacy decision. Adequacy decision is where the UAE data office or the country of UAE determines that a third country has similar level of laws, framework, or judicial structure which can adequately protect the personal data of the data subjects. Or the second situation can be where the state of the UAE has bilateral or multilateral agreements with that certain country. So this can be under a convention like what we have for like the Budapest Convention or certain OECD principles that the country is a part of it. So in those cases, we can share the personal data outside the UAE. In cases where a country does not have an adequacy decision given by the UAE, then there are certain ways that we can transfer that personal data. Those are like, the first thing is that we need explicit consent from the data subject that we are transferring the data outside UAE. The second scenario is where there's public interest involved, or if there is a scenario where there's international judicial cooperation, or sometimes we call that multi-MLATs. And the third thing is whenever it's necessary for performance of contract. So let's say, for example, you are selling a certain product or service to a data subject. And in order to give them that service, you need to share that data to your controller or to your parent organization, which is based out of UAE. So so if it's necessary for the performance of contract, you can share it outside your country. Lastly, is that you provide a contract which has sufficient or similar measures to what you are liable under the law. So let's say if the law asks you to do X, then you should ensure that you have certain contracts which tells that the receiving entity or the importer will have the certain similar obligations. So under GDPR, we have standard contractual clauses which poses similar or equivalent restrictions and obligations on the importer who receives that personal data. So this is something that we might be looking at in the future when we receive the implementing regulations. Lastly, there are certain measures that we have to take during a data breach. So if you are a controller, the first thing you need to do is that you need to submit whenever you receive awareness of data breach. Yeah, you have to submit a report to the UAE data office, and in the report, you need to put certain details like what was the nature of the data breach, what was the cause of the data breach, and the approximate number of records that have been part of the data breach. Second step, what you need to put is that what are the potential and expected consequences of the breach? Like, can it affect the privacy and confidentiality of the data subject? Can it create reputational damage to the data subject? Will there be financial losses to the company or to the country with that certain data breach? And lastly, what measures you've taken to mitigate that risk? So generally in certain data breaches, we've seen that the database which has been part of the data breach was already encrypted. So they ensure that either the keys are safely locked in so that the keys are also not part of the data breach, or they are given back to the investigative authority so that that's not stolen or will not be a part of a subsequent data breach. And lastly, you have to also put the contact details of a TPO. This is usually for the UAE data office to coordinate and communicate with the company whenever there's a certain data breach, so that the UAE data office or the regulator or the incidents response team of the country, they can take appropriate steps to prevent further effects from happening. The second step is that you have to notify the data subject if it would really prejudice the privacy and confidentiality. So this could be way of PR communication where you tell them to change their passwords or to put multi-factor authentication in the applications or the systems, the services that we use. Similarly, there's an obligation on the processor to notify the controller when they are aware of a data breach. The interesting question here is that if you're a processor based in the UAE and your parent organ or the controller or the parent organization is not in the UAE, should you still report the data breach to the UAE data office? And my interpretation would be yes. I don't think the UAE data office will appreciate if you're a processor and you do not report it to the UAE data office, and instead you wait for your controller or the parent company who is not in the UAE to report it to them. Ideally, we are waiting for implementing regulations on this, which would give us some form of clarity whether a processor needs to report this back to the data office, or should this communication come from the parent organization or from the controller. Yes, so there are certain rights that are given to the data subjects under the law. The first right that we have is right to access. Right to access basically means that whenever the data subject comes to you and says, hey, what data do you have on me? Then you have to give them certain data elements of the data you have on them. So this includes the type of personal data that you have. You don't have to tell them that we have Souryan Bhattacharya, your name and your email, the exact personal data, but you have to give them the data categories. You have to also tell them why we have this data on you. Thirdly, you have to tell them at least the category of entities that you've shared this data to. It could be your subsidiary organizations or your parent organization or to any third parties. You don't have to clearly mention what is that entity's name, but you have to at least tell them the category. Fourth, you have to give them the procedure if there's to be any correction or deletion or restriction of such a personal data. And lastly, you have to tell them the security controls you have taken for that personal data. So you don't have to tell them the exact security measures you have taken, but this could include that you have proper policies and procedures in place, and you have these kind of certifications which ensure the protection of personal data. The second right that these data subjects have is that they have the right to correct inaccurate personal data. So whenever a data subject is of the opinion that the data you have on them is incorrect or inaccurate, then they can raise such a request, and that request has to be facilitated without any further delay. The third right that we have is the right to deletion of personal data. So whenever a personal data is no longer required for a necessary purpose, then you have to delete the data or erase that data. And this can happen under certain scenarios, like if you withdraw the consent, if the data subject withdraws the consent, or if there's an objection by the data subject that, hey, you should not be using this personal data, or you should not process this personal data, then that is considered as an objection done by the data subject. And lastly, if the processing violates any of the provisions of this law. The fourth right that we have is the right to restrict processing. So this happens when the data subject says that, hey, you need to stop processing till a certain requirement is met. So this requirement could be three things. So the first thing is if the personal data is inaccurate, that's where you can say that, hey, just stop or restrict the processing till the time I correct the personal data. The second scenario could be that, let's say a data subject gave the personal data for an X purpose, but you are processing the data for a Y purpose, and that'll be contrary to the agreed purpose. So in those cases, the data subject can exercise their right to restrict. And similarly to the last law, if the processing violates the provisions or the obligations under this law, then the data subject can exercise such a right. The next right that we have is the right to portability. So data subject can, let's say, if data subject terminates their service or their relationship with the organization and wants their personal data to be transferred to another controller, then they can do so under this law. So you have to provide them that personal data in an organized or machine readable format like a .csv or .xml format, which then has to be transferred to another controller. But this is something that we've not seen happening too much, because there are certain proprietary intellectual property of an organization, or we do not have a common data sharing framework in place by certain organizations, which stops or restricts such a right from being exercised. And the next thing that we have is the right to stop processing. So this happens whenever we are processing data under consent. So whenever we are processing somebody's data under consent, then the data subject has the right to stop that processing. So this can happen under two scenarios. So if you're processing the personal data for a statistical survey, or if you're providing them direct marketing, then the data subject has a right to ask to stop that processing. And the last right that we have is the right to object to automated processing. So I'll give you an example. So let's say you go to a bank to apply for a loan, and there's an algorithm in place which is end-to-end done by technology, and it evaluates all the transactions you've done in your past, and then it tells you, okay, you're eligible or not eligible for a loan. So that is something that is considered as an automated processing. This also includes profiling, where you tell somebody that, or you make a decision on somebody's personal aspects. So in that cases, a data subject has a right to object to such a processing. So in these cases, you have to ensure that you have certain measures in place which protect their privacy and confidentiality. You also have to ensure that this does not cause prejudice to them. And lastly, you also have to apply for human intervention. So let's say if a data subject objects to such a credit or a loan sanction, and the application of the algorithm says that you're not eligible for a loan, then you have to apply some human intervention which double checks or cross checks such a processing and gives a final answer. Lastly, I wanted to touch briefly on, let's say, if you're a legal professional and somebody comes to you and says that, how do we implement a privacy program in your organization? So there are certain tips and strategies that you can take. The first thing is that you need a vision and a strategy document. So for this, you need to go to your board, or you need to go to the CEO, and you need to get the commitment that you want. This is the law. This is what we're trying to achieve, and this is the budget that we need to do this. The second thing is conducting a gap assessment. So you have to, whenever you gap assessment according to the law. So you have to figure out what this law says, and you have to review it, whether you have done this or do you need something extra, new policies or procedures for this. So you have to review your existing policies, you have to review existing procedures, you have to figure out what's required, and you have to figure out also the resource allocation for this. Thirdly, you have to develop a privacy policy. So when I talk about a privacy policy, it's not something what we talk about on a website privacy policy, but your internal organization privacy policy. So this has to be a very principle based. It has to cover the principles that are given under the federal law and other data privacy laws which are applicable to you. You also have to give high level roles and responsibilities that are applicable in this privacy policy. So you have to tell them that businesses or your sales team will be responsible for collecting the data. Your privacy team will be responsible for reviewing the privacy program. Your legal team will be responsible for reviewing the legal documentations or the vendor contracts here. The fourth step that you can take is to conducting reviews on the process, people, and technology. So you have to review the vendor contracts that you have. You have to take out the review the applications to ensure that they are complying with the certain laws or the data privacy laws that you have. You have to carry out risk assessments which ensure that they are actually complying with the law. And also you have to take care of awareness on training in your organization so that they know that this is the law and this is what they need to do on the law. You also have to review these against your privacy policy so that you can ensure that they are actually in compliance with them. The next step is that you can develop or amend your existing procedures. The procedures will detail out what exactly do you need to do under a certain obligation or a project. So let's say a differentiation between a policy and procedure would be that a policy will tell you, okay, in these scenarios, you have to carry out a DPIA, but how to exactly carry out a DPIA, that will be a part of a procedure. So you have to, once you have these process, people, and technology in place, you have to ensure that the procedures that you create or amend, they clearly reflect the duties. Duties here meaning what exactly they need to do, and responsibilities. Who should do this? Whether it's your IT team, whether it's your business team, whether it's your legal team or your data privacy team itself. These are the things that you need to highlight. Lastly is review, monitor, and report. You have to ensure that you regularly monitor the work that you're doing, or monitor the work that your business teams or your sales teams are carrying out with respect to their privacy obligations. And you might have to also create assurance reports, which you have to give off to your board or your committees, or this can also be part of the audit function in your organization, which will report that to the board or the committees that whatever your privacy team is doing or the frontline teams are doing are actually in compliance with the laws. All right, so if there is any Q&A, I can take that up.
Awesome. It was really enriching, Souryan. I mean, I think there were so many things that were clear, at least for people who are aspiring to build a career in privacy in the UAE. Thank you so much for guiding us from the basics to the complexities. So guys, now is the Q&A time. If you have any question related to privacy, please just raise your hand and we'll take the question. It could be any question. Okay. Oh, we have 2 questions already. So Lakshmi, you can go first. You can unmute yourself and ask your question.
Can you hear me?
Yes.
Yes.
Hi. It was nice. Actually, the session was really good. I have a very particular question. I don't know if this I can connect with the class you had now, but it is connecting to the bank privacy, data protection under the bank. We are actually specifically looking at a case right now for, with regard to that is what my question is. Like, how was the data, what happens to the data which all was collected for account opening if the account opening form was not used? What will happen to those account opening forms or the data in that?
All right. So one clarification here, the federal law does not apply to banking and credit related data, which is already regulated under a law. So I'm not sure the applicability of federal law on your question, but generally speaking, if you do not give an account opening form, did you use any other documents which would inform them that this is how their personal data will be used, or this is to which entities they will be shared, or collecting any consent out of that?
The question is not like how, like what happened to us. The thing is that they have already collected. They had 2 forms or so. One they have used and one they haven't used for the same purpose. So according to what we understand is they have used only 1 form. What happens to the other? And one more question is there. I understand the federal law doesn't apply because this is concerning to the DIFC. And like the collection of wherever I have read about the data protection laws and all, I have seen there's a saying about the collection, but the process of collection is not said. Like who can collect, like for instance, let's take the account opening form itself. Like, is that the applicant he himself have to fill in the form, or the bank can collect the data and they can fill in? Is there anything like that? Who can collect? How they can collect the information?
So that's very. I would suggest the data subject or the individual filling out the forms, and the bank's obligation here would be to clearly state out the terms and conditions, which include how the data will be processed. Ideally, in general practice,
the process means how the data will be used. That is what you're saying, I guess.
Correct. Yes.
Yeah, but the collection of data is also there. Not to process the data, they need to collect the data. How is the data collected? The collection process and everything is said in the data protections. Even the bank's data protection also it is said. Maybe the different banks have different data protections according to the rules which is applicable to them.
Yes. So you generally have to. So generally in account opening forms, you have a notice saying that these data are required to provide such a service. That is how you tell them that, hey, we need your name, we need your mobile number, we need your address or some other details so that we can provide you such a service or to open an account. This is the first thing that you can rely on to tell them that this is why we need the data, and how you will use the data. That can be part of the data processing form that you have in place.
Yes, but then if they have collected and they haven't used it for some purpose, like what happened to that is not said anywhere, I guess.
So I didn't understand the last part.
Imagine if they've collected, like as I said, they have collected a form filled by the applicant or someone, like who the informations are filled in, and that form was not used. That is an unused form.
Okay.
And some other form was used for processing the account or investment of anything. What happens to the unused forms and data in it? How is that protected?
Ideally, if you don't need personal data or that form that is in that personal data, you should be disposing it off. You should have certain controls in place to ensure that whatever data you're collected will be retained till the purpose you need. And if you're unusing it, the ideal way is to delete the data or to shred that paper so that there's no unauthorized use for that personal data.
Awesome. I think I hope this gave a detailed information to you, Lakshmi. We are short of time, so we will have to take another question. I think Atul, your hand was raised, so it will be great if you can unmute yourself and ask your question. Hi, Atul, are you there? I think we can go for. Okay. Hi.
Yeah, sorry. Yeah, so it was a great session, very insightful. Thanks to the speaker. and thank you for arranging. I have a simple question. Like, are there any upcoming sessions wherein we'll get to know more about in detail about UAE program, UAE data protection law? Because a
Yes.
few of my clients are there. Also, that or the speaker is arranging. Like I just wanted in detail, right? Because
Sure.
I feel it's the gist. So please keep us updated. Because probably being in India and in you people are, I feel, arranging from Dubai. So probably there is a time lag. So because I just now saw the mail that was with the reason I was able to attend it. So probably if you can just probably intimate so that we can register and get the benefit of that. So thank you.
Sure. So generally we post everything on the group a week prior than whenever the event is. So I request you to, stay updated on the group. Whatever information we're putting in, it's there on the Smart Lawyers group, and Brijesh sir also posted on his LinkedIn. But any other question related to data privacy? Any career related question, anything, anyone? Okay, I have a question for you, Souryan. If you can help people navigate, what are the few tips you have for, a future privacy law enthusiast in the UAE? Like, how can they build their career in the privacy domain, specifically in the UAE?
I think the time to enter the career, your privacy career field in the UAE is right now. Since that we have a federal law, I'm pretty sure the markets for privacy professionals will open up really fast. We have certain certifications in place, which like the CIPP, that is considered as a global certification. That will be a good first place to start studying and obtaining knowledge on how the data privacy field works. You can also look at other non-privacy related certifications like CISA, which teaches you on risk governance and risk management. And if you want to see, privacy is not just only on data privacy. You have to study and work in some aspects of data protection as well. So you have to see where you fit in your organization with that. So if you are working a lot in cloud security, and there might be some certifications with that might help you out. So the first step would be, yes, to get certain certifications like CIPP. That should be a good start.
Awesome. And do you recommend like pursuing an LLM in data privacy, or do you think straight out of law school people can, actually build a career in this space?
This sector is so new that anything goes. Like, I've seen people who have been working not even in IT or legal, and they have certain years of experience in a totally different field, and they've entered privacy. So since it's really new field, there are no very rigid rules about how to enter this field. And with LLM, I would certainly advise so. I'm also planning to do an LLM in data privacy soon. So, but there are not many colleges which give you. There are few in UK, there are few in USA, and very few in India, which actually have a very comprehensive LLM. So you'll have to do your research. And I would say time would be your best companion here, because I'm pretty sure as time goes, we'll have many more colleges which give you LLM programs in data privacy.
Awesome. I think that's about it from my end.
Just wanted to share in terms of LLM, and I just 2 days back I saw that National University is coming up with a program on cybersecurity and data privacy as such, so people can check out that also. Just wanted to share.
Oh, thanks, Atul.
Thank you so much. Thanks, Atul. I think that's about it. Anyone else who wishes to ask any question, please do. This is the right time, and we'll be closing the session in the next 5 minutes. Anybody, any other question? Awesome. So, Souryan.
Yeah, I had a quick question. Viditi here.
Yeah, I request to please raise your hand first and then unmute yourself.
Genuinely cannot find the raise hand button.
That's fine.
Trust me.
Go ahead.
Mr. Bhattacharya, thank you for this wonderful session. I am finally a law student, and I'm currently doing an internship with Beveron. And they're amazing. They're great. I'm having a ball of a time. I just wanted to ask you, how do you find working in data protection and privacy? Is it challenging every day? Is it monotonous? How is it?
It's very challenging. The unique thing about my job is that although I'm a lawyer, my data privacy team does not sit within the legal team, it sits within the risk management team. So I'm not only interpreting the law, I'm actually telling them what you need to do to comply with it. And that is something not lawyers teach in law school. So that is very interesting. And since it's pretty new, so there are no rules, no laws on how to comply with it. So you have to use your own creativity. You have to understand your organization. So it's pretty challenging and it's pretty fun also.
That's great to hear. That's great to hear. Thank you again.
Thank you.
Awesome. Awesome, guys. Any other question, anyone? Amazing. I think, guys, with this, we'll end today's session. Again, thank you so much for giving in your insights on data privacy in the UAE, Souryan. And we hope that we can do, similar sessions in the future as well for all the data privacy enthusiasts. And with this, I leave you guys to enjoy your Saturdays and have a great weekend. And please stay tuned on the group if you are interested to see the recording of the live session. And have a great one, guys. Thank you.
Thank you, Aashna. Thank you, Brijesh. Thank you, everybody.
Thank you. Bye-bye.